Hey gang, trial lawyer Ryan Pacyga, and that's actually what I'm going to talk to you about today is what is exactly a trial lawyer? You'll go by billboards, you'll be driving down the road, you'll see trial lawyer, you'll see websites for lawyer and they say trial lawyer, but what exactly does trial lawyer mean? And I want to fill you in on a little secret. So, trial lawyer, it might seem pretty obvious, right? That's a lawyer that goes to trial. Well, not exactly. Here's what I'm talking about. So there are a lot of lawyers that call themselves trial lawyers, but to be very honest with you, very few of them really are trial lawyers. And it's not always their fault. It's kind of been an evolution, and particularly in civil cases, which means lawsuits like a car crash or something like that, right? So of all the lawyers in America, the types of lawyers, the lawyers that go to court the most and the lawyers that end up in trial the most are prosecutors and criminal defense lawyers. And that's kind of out of necessity because the stakes are the highest, right? I mean, what can you put a price on your liberty? Can you put a price on your freedom? What amount of money would you accept in exchange for life in prison, for example, right? There's probably no amount of money, right? So the very high stakes nature of criminal cases is part of what makes trials more likely and more frequent in the criminal case world, right? Prosecutors and criminal defense lawyers. So those lawyers on average have the most trials, and it isn't even close compared to all the other lawyers. Now, those trials also involve juries probably 99% of the time. So there are some trials where there will be a bench trial only, meaning a judge only. But what you're typically thinking about when you think about a trial lawyer is a lawyer who goes to trial in front of juries. And that's a really important distinction. And I'm going to tell you a little bit more about it. So of all the kinds of lawyers, a lot of lawyers never end up in court at all. Think about, or very rarely, lawyers that draft contracts or wills or sports agents or those sorts of lawyers, maybe patents. Very unlikely that they end up in trials, and if they do, it's very, very few, right? So a lot of lawyers just never go to court at all or never have a trial in their whole life. But then there are some areas of lawyers or practices within law that lawyers do end up in court. So those can be, for example, divorce lawyers. They will have trials, although that's usually not with a jury, that's with a judge, right? And then you get some civil lawyers. Now, civil lawyers are lawyers that handle personal injury or other types of lawsuits. But let's talk about injury cases, car crashes, and things like that. Those lawyers often call themselves trial lawyers. And in fact, this reminds me, my first job out of law school, not long after 9/11, I got a job at a mid-sized firm, and they called themselves trial lawyers. Well, in the amount of time that I worked there, you know how many trials we had? Zero. Yet they called themselves trial lawyers. I think, in fact, the head partner for that trial team that I worked on, we probably went to court 4 times in an entire year, and none of the hearings were trials. These were motions to try to get a case thrown out or for summary judgment or a motion to dismiss. And that was it. And it was a big deal if they had court that day. So literally 3-4 days in an entire year where we even went into a courtroom, and none of them were trials, right? Yet they called themselves trial lawyers, right? And that's part of the misleading part. So again, not all of this is civil lawyers' faults or personal injury lawyers' faults. And the reason is that some of the culture now has been driven in American courtrooms, especially in civil cases, to make it hard to get a trial, or at least that's the excuse that the lawyers will say. And there is some truth to that, and here's why. Lawyers now are forced to do things like mediation, which means the judge orders both sides to go see a mediator and try like hell to get the case settled, right? So that's one thing that can get in the way of trials happening because there's pressure to settle these things at mediations or arbitrations. Second, civil cases can last a very long time, years. And this can wear people out. So they might end up willing to be able to settle a case where they wanted to go to trial, but they just can't wait any longer. They don't want to wait any longer, and they give in and they settle. In addition to that, some judges will pressure the lawyers to settle the case as well, besides a mediation, even if it's coming up for trial. There's pressure, right? But then here's the little secret part I want to let you in on. You know, think about this. If there's a civil lawyer, let's say they're doing crash cases, right? And they call themselves a trial lawyer, but a case is going to trial or set for trial, and you don't like the offer if it's your case, right? You want to go to trial, but your lawyer starts telling you, hey, you should settle. You got to settle. You got to settle. Why? What's probably going on with that lawyer is this. They are feeling internal pressure within themselves to settle the case, because if they call themselves a trial lawyer, but they haven't had any trials and they've been a lawyer 3, 5, 10, 15 years, or maybe they've only had 2 or 3 or 5 trials or even 10, that's not a lot of experience. And trials are a ton of work. It's like tip of the iceberg, what you see in court versus what we're really doing to prepare for it that you don't see. As well as the nights even during the trial that we continue working, because they never go as scripted, right? You're always pivoting for something that happened that day. So it's not uncommon for us lawyers who are really in trial to work 16 hours or more sometimes in a day, including 7 days a week. We just keep going and going as the trial's going, right? So at any rate, the lawyer is going to feel their own internal pressure because they don't want to look like an idiot in front of the judge if they don't know what they're doing mechanically in a trial, like picking a jury the right way, dealing with the rules of evidence or objections. All of these sorts of things that become obvious to a judge if the lawyer doesn't know what they're doing in the middle of the trial. They don't want to look like a fool in front of the judge. They don't want to look like a fool in front of their client, which is you. And they don't want to look like a fool in front of the jury or their law firm or anything else. And, of course, there's fear, right? If you don't have experience doing something, you may indeed have fear. So people don't want to try cases because that inexperience, in part due to the pressure to settle cases that judges put on people or law firms put on the lawyers or whatever, because settlements are guaranteed money, whereas you're rolling the dice if you go to trial. You can't guarantee what a jury will do. But I think you're leaving a lot on the table in cases if you don't. I mean, every case is unique, but the fear and feeling of having to settle a case ends up leaving people with having to leave a lot of money on the table because they just don't take the chance that they should have taken. Same goes for criminal lawyers, actually. There are a number of criminal defense lawyers or prosecutors who are also afraid to go to trial. And just because that area of practice ends up with the most trials doesn't mean that all criminal defense lawyers and doesn't mean that all trial prosecutors routinely try cases or try a lot of cases. Some of them have that same fear, right, for the same reasons I already discussed. So what is a trial lawyer? Well, a trial lawyer is someone who really does try cases and isn't afraid to do it and has experience doing it. I'd say 50 or more trials is a great number. If you're looking for a lawyer with trial experience, that's a really good number. Again, you want lawyers who have experience doing jury trials. It's much different trying a case to a jury than it is a judge, for a variety of reasons I don't have to go in on this video. But let me tell you the advantages that a true trial lawyer, and not just someone who says they're a trial lawyer, brings to the table, okay? And lawyers who try cases know this. And in fact, I've been hired by other lawyers who are criminal defense lawyers to try their cases. These are lawyers even with trial experience. But if you get good at this and you know what you're doing and you enjoy trying cases, which comes with a lot of its own stress, its fatigue, the risk, everything else, it's not for everybody. But having a true trial lawyer on your team can make a huge difference in your criminal case so that you're not getting pressured to settle a case you shouldn't and maybe plead guilty to something you shouldn't. Or in your civil case where you're suing for money and the insurance company isn't making you a fair offer at all, right? So here's how a trial lawyer sees a case from the beginning. Number one, like if you were going to go through the jungle, you'd probably want a guide to let you know which path to go down and where you should and shouldn't go. And if you encounter something that's a surprise, how to deal with it. And they can know, like, today isn't a good day to go into that jungle, and here's why. They have the experience. They can look far out and predict things and anticipate things and all that sort of stuff. A trial lawyer can do the same thing because we look at cases differently than lawyers who don't have trial experience, because we're able to look way ahead and understand what it's going to take to prepare for that trial long in advance, what a jury's going to be reacting to, what a judge is going to be reacting to, difficulties in the rules of evidence, even to try to get evidence that you want to bring in the trial. Just because you want to bring it in doesn't mean you can bring it in. So we're familiar with obstacles to getting your evidence into the trial that we want to get in, that we can anticipate what the defense, if it's a civil case, is going to want to object to and keep the evidence out. At the same time, they're going to try to get in evidence that you don't want in your case against you, and we know how to keep that out or make the best arguments to keep it out when they're trying to bring in something that shouldn't be brought into the trial. So we see these things long before, and we can start to prepare your case that way. In addition, we know how to discover the real story for your case, because here's what matters. The law is one part of your case, and the facts are another part of your case. And you might think, well, that's all there is to it, the facts and the law. Not so. Not so at all. Juries rely on feelings. They're told not to rely on them, but they can't help themselves. They're human beings. They don't have the training to isolate out some of these things as much. And so They decide first how they feel about something. And then after they decide how they feel about something, then they decide what the facts really are. And that might sound far-fetched to you, but that's the experience of trial lawyers. We understand that. It doesn't mean that no facts matter, of course. It doesn't mean that the law doesn't matter at all. That's not what I'm saying. But how a jury feels and how they're connected to your lawyer and how they're connected to your story in the case really makes a difference. That's a game changer. So a trial lawyer understands this. Trial is telling your story, not defending against the other side's story. Okay, they've got their own story about why you're guilty if it's a criminal case. They've got their own story about why you're at fault in the car crash, or if you're not at fault, why your damages aren't as high as you think they are and why you should be paid pennies on the dollars, right? That's their story, and that's what they attack with. Well, you don't want to defend against that story or you're losing, right? If you're defending, you're losing. Instead, you want to attack. And how you attack is you tell your story in the case, and you got to have a lawyer, a true trial lawyer, that understands how to do that. We understand what motivates juries. We understand what resonates with juries. We understand how to find the story that's buried underneath what they think is the story and work with that and develop that and find witnesses that support that and find documents or exhibits that support that and put that together. And once we have that as a theme in your case, then we know how we're gonna pick a jury and talking about the tough issues in the case, because we got to talk about those things. We can't run from those things. Right? So we have to know our theme. We have to know what to talk about when we're picking a jury so we can find out which juries are going to resonate with this part of your story. Are they on board with this? What are some things they're concerned about? Can we address those concerns for them in the trial, right? We have to know all of these things, and that goes into jury selection. And the jury you pick is so important in your case, of course, because they are the decision makers. If you're in trial, the judge is not the decision maker. The judge rules on evidence and objections. That's what the judge does. The lawyers aren't the decision makers. You're not the decision maker. The jury, those 12 people or those 6 people, are the decision makers in your case. And so what they think and how they feel matters greatly. Okay? So jury selection, a lawyer that knows how to bring this up, how to have these conversations with the jury that isn't so mechanical or robotic. I can't tell you how many times I've seen lawyers, prosecutors, defense lawyers, you name it, civil lawyers, who are just robotic or married to a script when they're doing it, and they're not connected at all with the jury, and you got to have that connection. So after jury selection, the opening statement, a trial lawyer knows how to bring your story to life, is kind of think of it as a movie preview, telling the jury what they can expect to see in the trial, and letting them know what's going to be important to look for as the testimony begins in the trial. So that's that next phase. And then we could talk about cross-examining. A trial lawyer understands, I think lawyers, when they're in law school or even after, even a lot of trial lawyers that don't go to trial much, they think that cross-examining always means crucifying the witness that they're cross-examining. Let me tell you, there is a time to do that, but there's also a time where that will blow up in your face. A trial lawyer understands how to do different cross-examine techniques, such as what's called a soft cross-examination, where we're not vilifying that witness, where we're getting the jury and that even witness, we can understand what that witness was going through. We can present some of the pressures that they were feeling and why they acted a certain way, or maybe even why their testimony isn't believable because of these other pressures, these internal pressures that they were feeling. But we don't want to do it in a way that's crucifying them unless the jury gives us permission to crucify them, because otherwise it will alienate the jury. If they think we're bullying up on a witness that doesn't deserve the bullying, that's going to not go well for us. So we have to know that. And that's knowing it through ongoing training. That's knowing it through experience in trying so many cases. These are difference makers in your case as well. And then, of course, direct exam. That means where the lawyer calls their own witnesses in the case for you, right? That means preparing you how to testify and how to make your story come alive in front of the jury, and how to make your own supporting witnesses' testimony come alive to further your story in the case, your true and authentic story, so that the jury sees you, your whole person, your story and who you are and what you're about and why you're in trial. They've got to see you. They've got to connect with that. They've got to understand that. And they've got to see your witnesses and feel the same way about them. And they got to see why some of the other side's witnesses are biased or untruthful or whatever that is, right? Or maybe that some of these witnesses are telling the truth too, and actually their testimony helps us. It doesn't hurt us like the other side thinks. So these are things that a trial lawyer understands. And then, of course, it culminates in the closing statement, right? Closing arguments, where we're carrying that theme that we started with, jury selection with the jury, all the way through the trial. And we're telling them why your side, your story, is the winner in the case, right? And that's what a trial lawyer understands how to do. So when you're looking for a lawyer, here's why it's always advantageous, if you ask me, to have a trial lawyer. Just because you have a trial lawyer on your team doesn't mean that you have to go to trial. You might not want to go to trial. But if you have a trial lawyer, your trial lawyer is going to maximize your chance at winning at trial if you go to trial, and also often will end up getting you a better offer in your case, whether it's a criminal case and you're a defendant, or whether you're in a civil case and you're the plaintiff and you're suing. And the reason is this: if the other side understands that the trial lawyer on your team knows what they're doing and is ready and not afraid to go to trial and has experience doing it and has a history of good results doing it, the other side knows that, and that often will affect the offer they make in the case. Sometimes it means they dismiss a criminal case. Sometimes it means they make you a sweetheart offer that you decide to take because you don't want to take the chance at trial, or you know you're dead in the water at trial, but at least you got an offer now that you're willing to take. Sometimes it's a civil case, it's a lawsuit, and all of a sudden your offer goes up tens of thousands or hundreds of thousands or even millions of dollars because the other side sees, wait, this lawyer is going to be really good with a jury, and they're going to ring the bell with this jury, and we better pay up because we can't take the chance of having a jury give them a lot more money. So we're going to give them quite a bit more than we were already offering. So the other side understands that as well. So the trial lawyer is the benefit because if you end up in trial, you've got a battle-tested veteran on your case that understands how to try a case, has success in doing it before, and can bring that home for you, okay? In the other event, even if you choose not to go to trial, at least your lawyer isn't going to be pressuring you because of their own fear or inexperience when they called themselves a trial lawyer, and you find out 2 months before trial that they don't want to go to trial and that they're afraid, and they're telling you, you've got to settle, you've got to plead guilty, or you've got to take this. offer that isn't worth the full amount that you should get, because deep inside they're afraid to go to trial for you. And that shouldn't happen. So do you see the benefits of having a trial lawyer? Do you have any questions that I haven't talked about here about what a trial is or what the benefit is? Please let me know in the comments. And if you found this video, I just like helping people and educating them. So if this was helpful to you, let me know, will you? I'd really appreciate that, and feel free to subscribe as well. Have a great day, and God bless.